Hi, my name is David P. Shapiro. I'm a San Diego-based criminal attorney, and I'm also the owner and managing partner of the law office of David P. Shapiro. In this video, I want to discuss with you some defenses and common occurrences when dealing with grand theft charges, particularly in San Diego. Grand theft requires, under Penal Code Section 487, that it be proven that there was a loss to another person, $950 or more. So, what are some common grand theft cases that my firm handles? A lot of times we'll get hired by former or current employees who are under investigation for grand theft by an employee. Under Penal Code Section 487, B as in boy, and then the number 3. What that requires, same elements, $950 or more of theft. And we see that a lot if it's someone who's in a position of trust, who has access to the company's records, bank records, payroll, those types of things. And they're accused of whether it's giving money to their friends, taking extra money for themselves, or taking property valued at $950 or more without the owner's consent and without a claim of right. So a defense a lot of times is, hey, I'm entitled to take this property. This was part of our agreement. I was told by a superior I could take this property. I'm entitled to this money. Those types of things. Other types of defenses to grand theft would be, well, it wasn't me. Yeah, it may look suspicious that, some of my friends received some money or some other disgruntled employees took some stuff, but I did not have that intent to deprive my business or this individual of that type of money. A lot of times, though, quite frankly, on grand theft, particularly grand theft by employees, since the burden is so low of $950, my firm deals with a lot of times, we're dealing with $80,000, $100,000 losses, and a lot of times even more. It's more of what's known as mitigation evidence than it is an outright defense. Sometimes with mitigation evidence, you're actually doing even more for your client than trying to put forward maybe not the greatest defense to a grand theft charge. So mitigation, main way to mitigate would be district attorney and the alleged victim saying it's $100,000. Through your investigation, through your work, and through your attorney's work, you're able to determine, well, it's not $80,000, it was really $20,000. Well, does that give you a defense to grand theft? Absolutely not. $950 is the threshold. But what that does is it makes a world of a difference in what your punishment is going to be if you're convicted. Maybe you could avoid jail time. Maybe you could get an alternative to any jail imposed where you don't actually have to be taken away from your family, where you don't have to be taken away from maybe your new job, and where you don't have to serve your time in jail. So there's so many things that could be done. Restitution is another key component of it. Let's say, hey, everyone's in agreement. It's $50,000 loss to the company. You're a former employee, and we work out an understanding that, hey, if we could work out a deal where you don't go to jail, you'll be able and have the earning capacity to pay back that money more quickly, and that could be a condition of your probation. So you want to make sure that you surround yourself with the law firm and hire a law firm when charged with grand theft charges in any capacity in San Diego that could basically lay out all the different options, all the different strategies, all the different defenses once they're aware of the state of the evidence against you to make sure they protect your best interests moving forward. My firm has extensive experience, both myself and our entire team, handling grand theft charges, particularly grand theft by employee charges and allegations. We ask that you give us a call if you or a loved one are facing grand theft charges and want our help, 619-295-3555.